Today's webinar is about the SEAD 4. SEAD 4 actually stands for the Security Executive Agent Directive 4. And we're going to go over that document, which is very important for security clearance and national security adjudications, and what you need to know for that particular document. So as Shannon indicated, my name is Ryan Nerney, and I am the managing partner of the Tully Rinckey California office. My primary practice areas are security clearance, federal labor and employment, as well as private California employment. Just as a disclaimer, the views here in this webinar or in this publication are mine and do not imply any endorsement by the U.S. government. This is for information purposes only and should not be construed as any type of legal advice. So to go over the agenda for today, I'm going to go over exactly what the Security Executive Agent Directive 4 is, so the SEAD 4. I don't want to say that mouthful the entire time, so I'm probably going to just refer to it as the SEAD 4. We'll go over why the SEAD 4 is important, the agencies that utilize the SEAD 4 for investigations and adjudications of security clearances, the adjudicative guidelines. So each one of those comes with disqualifying mitigating conditions, as well as the bond amendment. We'll briefly touch on that. That's also an aspect of the SEAD 4. And then the common themes or the common, we'll call it issues that we see for this SEAD 4 in general, and what can kind of trigger some of those disqualifying conditions. And what is the Security Executive Agent Directive for? So what is the SEAD 4? It is the directive to establish, or that establishes the general adjudicative criteria to determine eligibility for access to classified information or eligibility to hold a sensitive position for individuals who are required to obtain and maintain a security clearance for their jobs. The SEAD 4 covers individuals who perform work for or on behalf of the executive branch, so it doesn't necessarily have to be working directly for or employed by a government agency. It could be a contractor, a subcontractor who are performing or who is performing classified work for a particular organization or particular branch of the executive branch or agency of the executive branch, I should say. This excludes the president, obviously, the vice president, employees of the president and vice president. There are some exceptions to that, but I'll briefly touch on that towards the end of this presentation. But essentially, the president is the primary person who controls access to classified information, and that has been divvied out through various different government agencies through executive orders, the National Security Act of 1947, those types of things. So you see the next point here, it says the SEAD 4 is based upon the National Security Act of 1947, the Intelligence Reform and Terrorism Prevention Act of 2004, Executive Order 1054, Executive Order 12968, which is the primary one that kind of lays out the adjudicative guidelines, Executive Order 13467, which is another important aspect, and Executive Order 13549. These are all aspects that essentially were utilized in order to develop the SEAD 4 to determine the eligibility for individuals who need a security clearance to perform their job. So again, this applies to any executive branch agency authorized or designated to conduct adjudications of covered individuals in order to determine clearance eligibility. The last point here, which is actually a kind of a very, very important point, but a lot of times it's overlooked, is that you must have a sponsor for your security clearance. So in order for any adjudicators to even utilize the SEAD 4 in order to adjudicate somebody's clearance, a person needs an actual sponsor for a security clearance in order to be able to, go through the adjudication process. One can't just wake up, one morning and say, hey, you know what, I'm going to have a security clearance today. So I'll go ahead and start filling out the application. That's not how it works. You have to have a company, whether it's a contracting company, a government agency, a subcontractor, whoever, sponsor you for that clearance. And once you actually get the sponsor, then you can start the process of going through the whole adjudication process, filling out an SF-86, standard form 86, and kind of going through that entire process. The importance of SEAD 4. So SEAD 4 is important for various different reasons, but when it relates to security clearances, as I mentioned before, it sets out the adjudicative guidelines, which includes both disqualifying and mitigating conditions for anybody who's attempting to utilize or obtain a security clearance. Now, it's important it says adjudicative guidelines because essentially that's what they are. They're guidelines. So there is a lot of gray area within the SEAD 4. A lot of times it comes through practice and various different past experiences of what the government potentially looks for, or sees that there's a heightened risk for various different aspects. So there is some gray area there as far as the disqualifying and mitigating conditions, which again is why they're called guidelines. But essentially, there are 13 adjudicative guidelines. These are the 13 adjudicative guidelines that are always used and always looked at in order to determine if an individual should have eligibility for security clearance or access to classified information. As I said before, the guidelines are drafted in a way that leaves open interpretation by the adjudicating authorities. So a lot of times, if you actually look at the SEAD 4, it'll use language such as including but not limited to, those types of things. So it kind of gives the adjudicator a little bit of leeway in order to determine if somebody should have access to classified information. And because of that, there is no right line rule for what needs to be followed. Now, again, you can look at past cases and you kind of look at common themes and those types of things, as well as like past experiences that I've had in order to determine, if something should be an issue or should not be an issue. You can also look at the specific language, for reporting requirements in the SEAD 3, which is, goes through the reporting requirements. You can also look at the SF-86 and the specific questions on, what the government is looking for as far as information to be disclosed. But ultimately, because these are guidelines, the way they're drafted does leave open to interpretation. So, it kind of depends on who's actually looking at your case, investigating, and also adjudicating your case in order to determine if there is a disqualifying and or mitigating condition that is applicable. And this SEAD 4 is important because it provides the baselines for determining clearance eligibility. So for pretty much any government agency, I'll kind of get into a little bit of the nuances of that in a second. But essentially, any government agency is going to use the SEAD 4 or some sort of version of the SEAD 4 that has these adjudicative guidelines to provide that baseline to determine eligibility for a security clearance. And this also is important because it not only provides adjudicators, information as far as, what is to be looked at when determining if a person should have a security clearance, but it's also important because it gives those covered persons, people who are seeking a security clearance, an opportunity to understand what the adjudicators and or investigators will be looking for as well. So it's important to actually understand the SEAD 4, understand what it is, and review those adjudicating guidelines if you're going through any type of security clearance investigation or adjudication. The guidelines are used for all levels of clearances, so confidential, secret, top secret, SCI, SAP, restricted data, anything like that. It's going to be utilized. The only difference is that the higher you go, the more scrutinized you're going to be. At least that's what I found in my experience. So obviously, if you're only trying to get a confidential or a secret, probably not going to be as scrutinized as if you're trying to do SCI or SAP or something like that, which potentially can have some additional add-ons to that, such as like going through polygraphs, submitting additional forms, those types of things. Especially with like the intelligence agencies, a lot of times they do that. So that's why the SEAD 4 is important. Do all agencies use the SEAD 4? Primarily, yes. They may not use the SEAD 4 exactly, although I would say 98% of the agencies probably do. Don't quote me on that number, but it's probably around that. But there's other kind of versions of the SEAD 4, or maybe some add-ons of, like I said, sometimes depending on the level of clearance you get, you can be a little bit, more heavily scrutinized for, a certain type of clearance. But ultimately, it all comes down to the baseline of the SEAD 4 and those 13 adjudicative guidelines. So again, pretty much all use some sort of the SEAD 4 or at least some version of the SEAD 4 to determine if somebody should have a security clearance and for adjudication purposes. So the Department of Defense or Department of War, as it's called now, they use the SEAD 4 for all levels. If you're like an industrial contractor or something like that, so essentially if you're working for a contractor or subcontractor and you require a security clearance, they're going to utilize the DoD Directive 5220.6, which in and of itself, and enclosure 2 of that document is the actual SEAD 4 itself. So again, it's always going to utilize and go back to those 13 adjudicative guidelines. And the DoD directive, as it relates to contractors, incorporates several other agencies, including Department of Commerce, Interior, Justice, Labor, State, all those places. Again, this is for contractors. And they'll kind of utilize this particular document that, again, incorporates the SEAD 4 within that document for adjudication purposes as it relates to security clearances. As far as intelligence agencies, the 3-letter agencies that we all know, they typically refer to the Intelligence Community Policy Guidance, ICPG 704.2 and 3, which also, again, incorporates the SEAD 4. So within those documents, there is the actual SEAD 4 that's attached to those guidance, those policy guidances that, again, utilize those 13 adjudicative guidelines. They also lay out some additional things that you would need. Like I mentioned before, some intelligence agencies require polygraphs depending on what level of clearance you're trying to get. It provides for other standards specific to the intelligence community, but overall, it mirrors the DoD or Department of War, and it again incorporates that SEAD 4 in its guidelines or policy guidance, I should say, to determine if somebody should have a security clearance. Primarily for intelligence agencies, you're going to get, sometimes, very rarely, you'll do a secret. Most of the time, it's top secret with SEI. Sometimes you'll have special access programs, SAP or restrictive data, anything like that. That you will need, it will still go through the adjudicative guidelines. Sometimes it's even looked at if, let's say, you have a clearance coming from Department of War and you're trying to get reciprocity to go to one of these intelligence agencies, you need to get that higher level clearance of a TSSCI. They're going to look at that again, potentially go through their own internal adjudication, again, utilizing the SEAD 4, but still going through their own internal adjudication in order to determine if the individual should be able to get that higher level clearance. Department of Energy as well, 10 CFR 710, separate procedures for adjudications and investigations, although they're very similar, but again, still incorporates the SEAD 4 for adjudication purposes. So if you're ever going to go through Department of Energy, they have different names for their clearances, like a Q clearance and L clearance, those types of things, restricted data, those types of things, given its specialty, with like nuclear power and all those things. So that's codified in 10 CFR 710, but again, it still utilizes the SEAD 4 in order to determine if an individual with the Department of Energy should have a security clearance. So again, it all comes back down to the SEAD 4 and those 13 adjudicative guidelines for that. Other agencies not necessarily covered by the SEAD 4, although they do utilize the similar adjudication process, is the president, vice president, and their employees. Like I mentioned before, they typically have internal regulations and directives that mirror the SEAD 4. Sometimes you have heard something called Yankee White, essentially a rumor. I'm not going to kind of go into that because it is a rumor, but essentially that's just if you're trying to work essentially at the White House, it's just an enhanced review. But quote unquote Yankee White is not an actual clearance. You're still going to get a TSSCI or whatever the situation is, special asset program, whatever. It's just an enhanced review because you're going to be working at the White House with, potentially engage with the president or the national security advisors or anything like that. So there is an enhanced review for those types of investigations. The adjudicative guidelines. So as I mentioned before, there are 13 adjudicative guidelines that essentially each one of these agencies that we were previously discussing kind of look at in order to determine if somebody should have a security clearance. Now, these are very general, and some of them are utilized a lot more than others. But each one of these adjudicative guidelines lays out a definition of what that actual adjudicative guideline is. And then underneath what that actual definition is called the concern in the SEAD 4. What that actual concern is, it lays out what the actual concerns are for the government kind of generally. If you fall under or you've engaged in conduct or something like that that would potentially trigger a particular adjudicative guideline. And then each one of those lays out conditions that could raise a security concern and could be disqualifying. Again, there's a lot of gray area there. And it also lays out conditions that could mitigate a security concern, if you will. So, you have obviously guideline A, which is allegiance to the United States. That one we don't necessarily see very often. We did get a good chunk of those when they had like the January 6th, things going on. So there were some questions raised for that. But that's essentially, kind of give you some insight on that. We don't necessarily see that one too often. Guideline B and guideline C, they're kind of, similar. Guideline B is foreign influence. And guideline C is foreign preference. So a lot of times you see people who, maybe come from another country, they immigrated here and they still have family over in a foreign country. Maybe they have, previously had citizenship and they voted in a foreign election. They still have maybe one of their family members, served in a foreign military or worked for a foreign government. Anything like that could potentially trigger a guideline B and or a guideline C aspect. But realistically, a lot of times you just see that they just have, individuals who are trying to get clearances, guideline B is flagged or guideline C is flagged for just foreign contacts. Just be aware of that. Guideline D, sexual behavior. That's kind of self-explanatory. Guideline E, personal conduct. So this is the catch-all guideline. So anytime that something doesn't necessarily fit too well in one of the other 12 adjudicative guidelines, the guideline E is the personal conduct. So that's kind of the catch-all that basically says, if essentially there actually is another one that says, or an aspect of this that says if there's not if it doesn't fit particularly in another adjudicative guideline, then you should utilize guideline E for those disqualifying and or mitigating conditions. So guideline E, you'll see quite a lot in conjunction with maybe some other guidelines as well. I would say guideline E is probably the most common, just given the fact that it is the catch-all. Guideline F, financial considerations. That's, if there's any delinquent debt. Again, the debt would be delinquent, not necessarily just debt itself, but delinquent debt, getting some sort of, having some financial means that are, not reported, maybe some criminal aspects, any type of financial crimes, not paying or filing your taxes in a timely manner. Any of those things can trigger financial considerations. Guideline G, same situation. It's pretty self-explanatory. Alcohol consumption that usually triggers if you are an alcoholic, potentially getting treatment. Although that doesn't necessarily always trigger a guideline G if you're recovering and those types of things. Any alcohol-related conduct like a DUI, drunk in public, anything like that could potentially trigger a guideline G. Guideline H, drug involvement, substance misuse. Again, pretty self-explanatory, but essentially that's any type of illegal drug use or misuse of prescription drugs. That's typically what that involves. We do see that one quite a lot, as well as guideline G, we see quite a lot. Guideline I, psychological conditions. This is one that is basically if somebody has a mental health condition that that also impairs their judgment, reliability, trustworthiness, those types of things. So the fact that you may have a mental health condition is not in and of itself disqualifying. However, if it's determined that one, that you're not getting treatment for it, maybe, or if there is some sort of aspect of that mental health condition that does impact your judgment, reliability, and those types of things, that could trigger a guideline I. Guideline J, criminal conduct, self-explanatory. Guideline K, handling protected information. So this is like mishandling of classified or sensitive information, whether it's intentional or not. It doesn't necessarily have to be classified. It could just be protected. It could be PII information from even like a government contract or something like that. So that's typically what you see at guideline K. Guideline L, outside activities. That's essentially just like involvement in some unsavory organizations, those types of things, potentially overthrowing that have some aspects of overthrowing the government, those types of things. So any involvement in those types of outside activities potentially could trigger a guideline L, although that's very uncommon. And then the last one is guideline M, which is use of information technology systems. So if you're misusing, government computer, sometimes we see this triggered if, somebody's looking at pornography on a government issue computer, something like that. Even something as simple as giving out your own password to somebody else, I've seen trigger a guideline M before. So those are the 13 adjudicative guidelines with a little bit of insight as far as what potentially could trigger those guidelines. But again, these are what are included in the SEAD for adjudicators and investigators to kind of look at to determine if somebody should have a security clearance or not. As I mentioned before, the adjudicative guidelines have disqualifying and mitigating conditions. So for the disqualifying conditions, each guideline sets out, again, it's not a complete list, but it gives you kind of an idea or some guidance, if you will, of what those disqualifying conditions are, and guides the adjudicators on what factors may disqualify a candidate from obtaining a security clearance or security clearance eligibility, or even maintaining a security clearance. As I mentioned before, it doesn't include every aspect that could be argued under each guideline, but it does give a good baseline for what adjudicators should look at. Same thing for mitigating conditions. Each one of those 13 adjudicative guidelines does have mitigating conditions that also provide for factors that can be considered in mitigating under each one of these guidelines. This is the main aspect used in order to fight a security clearance denial or revocation, to show mitigation and those types of things. So it's important to understand the difference because this is an administrative process. So, there's disqualifying and mitigating conditions. It's not like an innocence versus guilty thing. While you can, if you didn't actually engage in the conduct that's alleged, you can use that as a mitigating condition. But ultimately, the mitigating conditions are important to understand. And to argue. So just because you engage in that potential concerning behavior doesn't necessarily mean that you won't be able to mitigate that and ultimately get a security clearance. The next aspect that's also included in the SEAD 4 is called the bond amendment. So this essentially provides statutory restrictions on eligibility determinations and also establishes various different waivers if you do kind of meet one of those prohibitions for granting a clearance. So essentially anybody is prohibited from getting a clearance for somebody who is an unlawful user of a controlled substance or addict. So this is a current user. So like, for instance, if you smoked marijuana yesterday and then haven't done it today, you can kind of make the argument you're not a current user. We've even had, attorneys at this firm who have represented individuals who have actually used an illegal substance in close proximity or very close proximity, I should say, to an actual security clearance hearing, which we've been able to mitigate. But it's essentially you just have to be an addict is what I usually refer to, and that's not used very, very much at all. Sometimes you'll get a judge that kind of goes rogue a little bit. For the most part, though, you're not really gonna see that too much. Even if you are using a controlled substance, it's a very high bar to hit for an actual prohibition for a clearance. Um, it's also if you would potentially be, and that's just for security clearance in general. Ultimately, you could be disqualified for just a higher level security clearances via the bond amendment for an SCI, a SAP, or restricted data. If you had a dishonorable discharge, you're determined mentally incompetent, or you were convicted and imprisoned for over 1 year. So essentially, you were convicted of a felony and actually served over 1 year of jail time. And at that point, you would just be disqualified from one of those higher level clearances. However, there are waivers available for these types of things. You may be provided for disqualifications with consideration of mitigating conditions. So, for instance, if somebody engaged in this type of behavior, but they're able to provide some, additional mitigation, there potentially could be a waiver granted to get them that higher level clearance if they need to. There's common themes and guidelines for SEAD 4 clearances and clearance adjudication. So the common guidelines that I see, I kind of referenced this before, is guideline E, B, G, H, and J. Those are the most common ones that we see. Guideline E, again, like I said, is because it's the catch-all, so they kind of throw that in there, as maybe an attachment to another one of those adjudicative guidelines. B, as we referenced before, especially with the intelligence agencies, a lot of times they have interpreters or something like that have family overseas. So the guideline B, the foreign influence, is going to be triggered. G and H for the alcohol and drug use. I think that's self-explanatory, as well as the criminal conduct. I think that's also self-explanatory. So those are the common ones that we see. And then finally, the common pitfalls, just to kind of add to this, because these are things that we see when adjudicators are utilizing the SEAD 4 to make these adjudications. It goes back to where everything started. Excuse me. So it's important to be accurate on your SF-86. That includes, being open and honest and candid from the beginning, making sure you're thoroughly reading the questions on the SF-86 before you respond, providing all the information that is being requested by the question. It's very important to do that. If you don't do that, then that's kind of where the personal conduct guideline E issues potentially could come in and could have a hindrance on your ability to get a clearance in the future. Also, there's an aspect if you fail to cooperate with investigators, that potentially could be reviewed as a guideline E issue. And ultimately, if there is a guideline E issue, then that potentially could cause some problems down the line. So thank you so much for attending today, and keep a lookout for additional webinars that we have coming up.